Grantham. He's been practicing law in San Diego County for 30-something years. His practice focuses on intellectual property and entertainment law, including trademarks, domain names, copyrights, trade secrets, licensing, motion pictures, TV, and music. He graduated, I can't say cum laude with a straight face, from Alfred University in New York and received his law degree from the University of San Diego in 1978. He was chairman of the board of the San Diego Film Commission from '98 to January 2000 and was a member of the board of the directors from '98 to 2007. He was legal chair of the Pacific Southwest chapter of the National Television Academy for approximately 2 decades and is a member of the State Bar of California's Intellectual Property section. He's a member of the board of directors of the San Diego Music Foundation, writes and speaks regularly about entertainment and intellectual property, law matters, including regular annual appearances at Comic-Con. I'm most pleased to introduce, and please help me welcome, Dave Grantham.
Thanks all for coming, of course, by the way. And let me start with a question. Have any of you, either in the last year or two, acted as a troll or received or had a client who was being pursued by a troll, by a show of hands? A couple of us. Okay, so to the rest of you, this may be something of a new topic, or maybe something you've heard a little bit about, but we're going to try to dig into it a little bit tonight because I think it presents some really interesting legal issues, specifically having to do with copyright and, of course, litigation and that nexus or that borderline between proactive lawyering and extortion. And this really tests that borderline very, very, very much. So let me start with a story that may help put some shape on this. Once upon a time, about 3 months ago, there was an 83-year-old widowed grandmother that we'll call Margaret for our purposes, who, living up in North County, had, out of the goodness of her heart, when her adult 50-year-old son returned to San Diego after living elsewhere and couldn't quite muster the money together to put up the deposit for his cable TV internet account with Cox, Grandma Margaret not only put up the money, but put the account in her name. Flash forward a couple of months, ring, ring, and Grandma Margaret gets a phone call that goes something like this. Hello, Mrs. So-and-so, my name is so-and-so, and I represent XYZ Production Company, and our private investigator has determined that you've been downloading Punk Rock Orgy in the Woods without permission, and we have filed a federal court copyright infringement lawsuit and are prepared to name you as a defendant in this lawsuit. But if you'd like to settle with us right now for $3,400, we have a website and we accept Visa and MasterCard if you'd like to avoid the hassle and embarrassment of litigation. By the way, you could be liable for damages of up to $150,000. May I have your credit card information now, please? True story. True story, and it's going on all over the country. I've read some pretty reliable estimates that in the last 2 or 3 years, there are about anywhere from 100,000 to 200,000 people who either have received these kinds of phone calls or letters or are about to. The first part of the handout, did everybody get a handout? The first part of the handout is a little article that I wrote that sort of generally describes the situation, how it works, why are the film companies and production companies doing this, what's wrong with it, and is anything being done to challenge it. And what we're going to do tonight for the little bit of time we have available is dig into some of those questions a little bit more in detail. And then what I've also done for your amusement and edification, because I'm a big believer that a picture's worth 1,000 words, is I've attached a few sample documents to your handout so you can actually see in real life how one of these cases progresses. And let us start with the notion that piracy is a real problem. There's no getting around that. Now, there are all kinds of positions about whether or not piracy is a good thing or a bad thing. If you're a content owner, a studio or otherwise, piracy is a bad thing. If you're a user of the internet and otherwise, you might think piracy isn't really piracy, it's just free use of content that's out there on the internet and information wants to be free. But I think as lawyers, we can probably, or lawyers in waiting, we can probably agree that to some degree or another, piracy is a problem. How much of a problem is to be debated. And then in the context of this business model that we're going to talk about tonight, or that we are talking about tonight, I'd say, based on what I've seen, there are about a dozen law firms around the country who are really primarily leading the charge with this business model, which is file a copyright infringement lawsuit in federal court and name anywhere from 5 to 25,000 does. And the 25,000 number is not an exaggeration. I haven't seen a lot of those cases. Most of the cases are in the category of 5 to 500 does, but there is one case where 25,000 does were named, were identified or listed. Not named, actually, as the case may be, in reality, which is part of the evil genius of the whole business model. But there are about 24 law firms that are leading the charge on this. And historically, they are basing their business model on a business model that was implemented and started by a British law firm about 4 or 5 years ago. And then the word kind of spread that this was working and a good way to make money. So then several law firms here in the United States have picked up on the business model, and now several more have picked up on it. But really, the 100,000 to 200,000 does that have been and are being targeted right now in hundreds of lawsuits around the country, really there's about a dozen law firms behind it. So where does it start? Well, it starts with, and you'll see this is Exhibit 1, it starts with a complaint like this, Boy Racer Inc. versus Does 1 through 60, where the plaintiff production company, more often than not, from what I've seen, they tip the production companies, and the plaintiffs tend to be XXX adult-oriented production companies. There have been a couple of mainstream production companies, and I say mainstream to the extent that one could argue that XXX adult fare has become mainstream, but just for purposes of our discussion tonight, I'll put XXX adult on one side and traditional mainstream films like The Hurt Locker, which won the Academy Award a few years ago, and The Expendables on the traditional mainstream side. Most of these cases are being brought by the XXX adult-oriented production companies. And it'll start with a complaint which basically federal court, it's always, I shouldn't say always, it's mostly federal court. There are a few law firms that are mining these types of cases under a slightly different legal theory in Florida state courts, because Florida state court law has some unique peculiarities to it that allow these cases to proceed with early discovery on a much more expedited and easy basis than they would under federal law. But for the most part, I'd say 9 out of 10 of these cases are being brought under federal law in federal court. They typically state a claim for copyright infringement, and then they'll throw in a claim either for civil conspiracy or for negligence. And I'll explain the civil conspiracy and negligence theories in a second. What's interesting about the business model and federal court is, first of all, as many of you may know, typically copyright infringement claims must be brought in federal court, cannot be brought in state court. Federal court has exclusive jurisdiction over copyright infringement claims, unlike trademark infringement claims where state court and federal court have concurrent jurisdiction. The claim can be brought in either court. But with copyright infringement, it must be brought in federal court. Here's the genius part of the business model. Whether you name one defendant or 25,000 defendants, you only pay one $350 filing fee to get into court. So now, with a $350 filing fee, you now have potentially dozens, hundreds, or thousands of Doe targets on the hook because you have filed a federal court copyright infringement lawsuit, and you now have the halo or imprimatur of federal court with which to proceed with your claim. So that's step one, is filing the federal court copyright infringement lawsuit. But I questioned the plaintiff's lawyer on numerous occasions, and I demanded on numerous occasions that he provide me with a copy of the copyright application or the copyright registration certificate, which is a key to the courthouse, right? Federal copyright infringement, you must have, at least in the Ninth Circuit, you must have a copyright application on file in order to bring a copyright infringement action. The plaintiff's lawyer refused to provide me with the copyright application or the copyright registration certificate. He claimed it was irrelevant, and his position was their client didn't provide free discovery to non-parties, which becomes more ironic as we get further into the case and we look further at some of the exhibits, and you'll see the discovery requests that they made to my client, who was still a non-party. But when I asked for discovery, when I asked for a copy of the copyright application or the copyright registration certificate, he refused on the basis that they don't give free discovery to non-parties. I think the real reason was there was a defect somewhere in the copyright application or the copyright registration certificate, and the plaintiff's lawyer didn't want to reveal that to me. And of course, I was representing a non-party, so I didn't have a whole lot of room to do much in terms of requesting discovery at this point in the case. So they start with the complaint. Then, right after they file the complaint, look at Exhibit 2. Exhibit 2, again, before naming anybody or before serving anybody. Oh, by the way, I'm sorry. The last page of Exhibit 1, you'll see, which is labeled Exhibit A at the bottom. This is the typical attachment that's attached to the complaint. It's a list of IP addresses that supposedly participated in the BitTorrent swarm, which was the cause of the film in question being downloaded and uploaded without permission. Who wants to give us a 10-second or 20-second summary of what a BitTorrent swarm is? Anybody? Okay, BitTorrent is a file sharing protocol, sort of an advanced version of Napster. It's an advanced version of peer-to-peer file sharing, and it allows multiple people to share bits and pieces of a file at the same time and allow it to be uploaded and downloaded without necessarily the permission of the copyright owner, and is accused of or is said to be often used for illegal downloading and uploading of films. So the plaintiffs have an investigator who supposedly goes online and using advanced proprietary technology, which they've never actually had to reveal in a court of law yet, but they assert it in all of their pleadings. Using advanced proprietary technology, they identify a group of people who are uploading and downloading the film in question at the same time. They identify their IP addresses, but they don't know who their real names are. So they attach the IP addresses as an exhibit to the complaint. Then, either the same day or the next day or the next week, they go into court, again, ex parte. There's no defendant yet. There's no named defendant. There's nobody representing any of these does at this point in time. They go into court and they file a plaintiff's ex parte application for leave to take expedited discovery. They file a canned 13-page brief which if you look at it, it looks very well thought out and very reasoned and cites cases. And to the busy magistrate who doesn't have anybody saying no, why are you doing this, magistrate? Why are you doing this, judge? The magistrate looks at this and says, gee whiz, this looks legit. Maybe I should grant this ex parte application for expedited discovery. It's accompanied by a similarly long affidavit of the investigator who cites all of his background and experience and all the reasons why his methodology is rock solid and not subject to dispute. And more often than not, the judge grants the ex parte application for expedited discovery, allowing the plaintiff to serve a subpoena on the internet service provider or the cable company, demanding that the internet service provider turn over the name of the account holder associated with the IP address. So now, once they get the information from the cable company or the internet service provider, they now have your name and address, your name and address, your name and address, and thereupon starts the phone calls and the letters. As for the letters, take a look at Exhibit 3. This is a typical letter, which basically in a nutshell says, we caught you, we believe you're infringing our client's copyrights, you're liable for damages of up to $150,000 plus attorney's fees. This is a pretty serious matter, but if you want to settle the case for $3,400, read our frequently asked questions, fill out the payment authorization form, and we'll sign the release, all of which is included in the package. Now, most people get pretty scared at this point. They're scared about federal court litigation. They don't really understand that they haven't been named as a defendant yet, or maybe they do understand, but they certainly don't want to be named. They really don't want to be outed to their spouse or their employer. And why $3,400? Why $3,400? Because $3,400 is enough money to make it worth the plaintiff's while to follow this business model, but it's not enough money to make it worth the while of the average target to go hire a lawyer. It's just the right amount of money to force a settlement. And I think they've been doing this thousands and thousands and thousands of times. And I am looking forward to the opportunity someday to be able to actually do some discovery and find out how much money the plaintiffs are making from their litigation versus from selling their films. Okay, so the letter comes next, and you know, this is sort of it's not the fruit of the poisonous tree, it's sort of going for the low-hanging fruit. Meaning they know, the plaintiffs know, that for every 10 people that they send one of these letters to or make a phone call to, a certain number are going to settle right away. A certain number are going to ignore them completely, and they might find them and might be able to track them down, or they might not. And a certain number are going to fight back. But what they've learned from experience is that enough people are willing to settle for the $3,400 or the $4,400 or the $2,400. Each one of these companies has a different number, but they're in the $2,400 to $4,500 category typically, because, as I said a moment ago, that makes it not very attractive to go hire a lawyer. There's enough settlements going on that it's worth pursuing the business model. And like I said, they start with the copyright infringement, and then they'll throw in a claim for either civil conspiracy, because all these people were conspiring together, although there are now more judges who are fighting, not fighting back, more judges are questioning the theory of whether people who participate in a BitTorrent swarm on different days really are possibly guilty of civil conspiracy. It doesn't fit the traditional model of a civil conspiracy. And the other theory that the plaintiffs are pursuing, and they have, as far as I know, have not gotten one of these to trial yet, or even to a motion for summary judgment, is that the mere act of having an unsecured wireless router or internet connection in 2012 is by itself negligence per se. That we all, in other words, that we all know enough about what goes on in the internet that we should have a secured internet connection. And if we don't, we are the legal equivalent of the guy who leaves his keys in the ignition of the car with the engine on, and when the little child gets in the car, drives down the road and gets in an accident, then the owner of the car is guilty and is liable. We, or anybody who has an unsecured internet connection, is guilty of negligence in the same fashion. That's the theory. There's not a single case on point that I'm aware of, but they're hoping to make law. I have an unsecured wireless connection. My next door neighbor could be hacking into my computer connection, or somebody down the street, or somebody parked in front of my house. You can't prove it's me. The plaintiff's position is, if you have an unsecured internet connection, you're guilty because on a negligence theory. And it doesn't matter if you say you had a party, or you had 100 people in your house, or your nephew was visiting for the summer, or anything like that. So we've got the complaint, we've got now the expedited discovery to the internet service provider, which coughs up the true name and address, and we have the letters and the threatening letters and phone calls. Some targets in some courts have filed motions to sever on the grounds that there is no basis for joining multiple does who have nothing to do with each other in one lawsuit. They may be in different jurisdictions. The alleged wrongful acts may have occurred at different times. And some judges are granting motions to sever, and they're leaving only doe number one in the case. And other judges are denying the motions to sever on the grounds that it's premature to file a motion to sever before discovery has taken place. So we're getting inconsistent rulings from judges all around the country. Now, what happens if the target who gets the letter or the phone call doesn't settle? Well, the next thing that the plaintiff's lawyer will do will be to go back into court, ex parte, typically without notice, and file a motion requesting leave to take the target's deposition before the target, again, before the target has been named, before the target has been served. And the next thing the target knows is they're being served with a deposition notice to show up at a deposition where, interestingly enough, at least in the one case that I had that went as far as a deposition, the plaintiff's lawyer showed up. For you litigators out there, you'll get a kick out of this. The plaintiff's lawyer showed up without a court reporter, showed up with a notary public who swore in my client, gave them the oath, and went away. And then the plaintiff's lawyer started asking questions. My co-counsel on the case is a seasoned litigator, and after an hour of objecting to just about every single question that the plaintiff's lawyer asked and getting the plaintiff's lawyer off his game, the deposition ended in an hour and 15 minutes, and the plaintiff's lawyer forgot to do what he was supposed to do under the Federal Rules of Civil Procedure. When you videotape a deposition, there are some very specific rules, I think it's Rule 34, that the plaintiff's lawyer has to follow, and if the plaintiff's lawyer doesn't follow the rules for closing the deposition and taking care of the tape recording or the digital recording, the video recording is useless and inadmissible. And 10 days later, we got a dismissal of the case.